And I'd like to begin my presentation by acknowledging the traditional owners of the land on which we're meeting. My paper is something of a shift in focus from Kate's very interesting presentation, because I'm moving away from the intervention treatment side, looking at some policy issues. And basically, I'm trying to address here something that's, I guess, been bothering me for some time about aspects of alcohol policy focusing on Indigenous drinking issues. Let's see if I can actually use this. No, so we have to do it from here, is it right? Yep, okay. So just to give an overview of what I want to look at, I'm really proposing a critical examination of something that is a distinctive, or I want to argue is a distinctive feature of policy approaches to Indigenous alcohol issues in Australia. And that's this important role ascribed to something called the community. And I'll say a little bit about how the community is conceptualized. But there is this difference that we don't expect places like Paran or Wagga Wagga or the West End to manage their alcohol problems. We don't put this responsibility onto places that are not largely or entirely Indigenous communities, and yet we expect Indigenous communities to assume a responsibility for managing the drinking of people who live in that community. So what I want to do today is look at three aspects of this. First of all, I'll talk a little bit about the emergence of alcohol management plans as the most recent manifestation of this idea of the local community as an agent of managing alcohol. Then I want to step back and look historically at where this idea has actually come from. Then I'm going to look at two case studies in which I try to look behind the policy and say, well, what actually happens in practice? And then I'll finish up by talking briefly on what I see as the implications of this state of affairs. So, beginning then, and I guess I should explain why I'm doing this. And the reason is because I want to argue that the rhetoric of community management, alcohol management plans, partnership with communities and so forth, this rather benign, nice-sounding rhetoric often conceals far more than it tells us about what's going on, what's driving alcohol problems, and what we can actually do about them. So I think it is important to go beyond this policy rhetoric, as I've called it. So I'll start with alcohol management plans. I was going to say they are the current policy instrument. I think actually they're about, at the federal level, they're actually about to be abandoned as the preferred policy instrument. But nothing has been publicly said yet, and I don't fully know what's going on. But the notion of alcohol management plans as a key instrument of policy really dates from the beginning of this century and started with an inquiry in Cape York, which was commissioned by the Beattie Labor government in Queensland, in the wake of mounting evidence of really high rates of alcohol-related violence and other harms in Cape York communities. And I'm not going to retail any of that evidence here. I'm going to take it that we all accept the fact that alcohol misuse is a serious problem in Indigenous communities. So I'm not going to regale you with stats. But certainly the evidence coming out in Cape York through, especially in the second half of the 1990s, was fairly bleak, and also there's a bit of agitation going on, as a result of which Beattie commissioned Justice Fitzgerald, to have a look at what was going on, and he painted an extremely bleak picture of what was going on in Cape York. And in response, in I think 2002, the Queensland government came up with this idea with the catchy title of Making Choices, Meeting Challenges, or the other way around it might have been, because all policies have to have a kind of a badge nowadays. But the key elements of the government's response was, first of all, that community councils were to be divested of managing licensed clubs, that alcohol management plans were to be developed in communities in consultation with those communities, that a central role in this exercise was to be taken by community justice groups, which were given increased statutory powers as part of this whole exercise. And as many of you would be aware, over the next few years, AMPs were implemented in 19 communities, both in and beyond Cape York. A couple of years later, the Northern Territory government picked up the idea of alcohol management plans. They commissioned what they called an alcohol framework document, and central to that document was this idea of alcohol management plans. And they defined alcohol management plans, as you'll see there, plans negotiated between all or some of the following. And I won't bother reading that out because I'm sure you can all read it. But the notion was that AMPs would be a way of empowering local communities, of developing strategies for managing alcohol that were tailored to those communities, but that would also lock in governments and others to provide the necessary resources. That was very much built into the definition. And the Northern Territory government sort of took on the idea of AMPs. However, in 2007, the notion of locally tailored solutions in Aboriginal communities was abruptly steamrolled by the Northern Territory National Emergency Response, or as it's better known, the intervention. Under the intervention, and again, I'm not going to go into detail here because I'm sure you're aware of the main features, but the Commonwealth came in and imposed a blanket ban on possession and consumption of alcohol on all Aboriginal land in the NT under the Land Rights Act, with some exceptions that I won't go into. Then, although, of course, that was a highly contentious policy, in its main features it was actually retained by the Labor government that replaced the Howard government in 2007. However, in 2012, the Labor government, the federal government, the original legislation for the intervention expired on 30th of June 2012, and the can't remember if it was the Gillard or Rudd government, Gillard government, I think, actually replaced it with what it called Stronger Futures in the Northern Territory. And in that legislation, it actually brought back AMPs as the central instrument for developing alcohol control measures at the local community level. It went on, and I haven't detailed it, I'm not discussing it here, it actually imposed also a number of what were called minimum standards, which actually have become something of a straitjacket on the development of these alcohol management plans. Over this period, AMPs were also introduced into a number of regional towns in WA and in South Australia. Now, these AMPs, of course, are not all the same, but they do have a number of common characteristics. Firstly, they're usually focused either implicitly or explicitly on Indigenous alcohol issues. So they're either developed for places which are Aboriginal communities as such, or developed in towns like Port Augusta where there is a substantial proportion of Aboriginal people, and when alcohol problems are defined largely as public drunkenness by Aboriginal people. That's the de facto definition often. All of these plans do ascribe a central role to local communities for managing alcohol problems. They have all, or not all, but a lot of them have generated continuing controversy, particularly the Queensland ones. 2013, I think, or might have been 2014. In fact, they were challenged in the High Court on the grounds that they violated the Racial Discrimination Act. That challenge was unsuccessful. There is some evidence that AMPs in far north Queensland have contributed to a significant reduction in injury rates, but there is a lot of counter evidence and often some fairly lurid media coverage as to what is alleged to have happened. In the Northern Territory, in fact, they've become so bogged down that 5 years after their introduction, there is precisely one AMP that's received formal approval. What's happened here? So as I say, in the Northern Territory, the whole process has become very, very bogged down. But the point I want to pick up here is that, in a sense, AMPs are nothing new. They're the new version of a much older idea, and that's this notion that the community is this somehow responsible for managing alcohol. So I want to go on now to say, well, where does this notion come from? Well, I would suggest that its origins go back to the ending of assimilation in the 1960s. In the 1960s and early 70s, throughout Australia, 100 years of formal prohibition on Aboriginal drinking, on possession and consumption of alcohol by Aboriginal people, came to an end. The various states and territories rescinded that legislation. So we had, as I say, this major change, legislative change, as part of the assimilation program of the time, because part of assimilation was this policy of trying to mould Aboriginal people so they would be good mainstream Australian citizens. And so one of the ideas of that was to remove forms of discrimination that seemed to have perhaps outlived what they regarded as their usefulness. So that was part of removing the ban on Aboriginal drinking. It also, however, came about because of quite a lot of activist opposition to that and other forms of discrimination throughout Australia. And there was also the issue of Australia was copping quite a lot of international flack because of its discriminatory policies. So the government of the day was quite keen to get rid of forms of discrimination that it could then present itself in fora like the United Nations and not get beaten around the head quite as much as it was. These were the days of the Cold War, of course. But the context in which this all happened was perhaps in many ways an unfortunate context. And again, this is fairly well known that, for example, at the same time as in Northern Territory that the ban on drinking was being lifted, you also had the cattle industry award case, as a result of which Aboriginal people had to be given paid minimum wages in the cattle industry, not equal pay, as is often believed. So there was a lot of the cattle stations actually sacked their Aboriginal workers. This led to more of a drift into town. It also coincided with increased access to welfare benefits. So you had this more people in towns, around towns, with money and with legal access to alcohol. Not the greatest combination in the world. You also, of course, had at this time, there was developing an increasingly powerful critique of the whole assimilation policy, particularly its suppression of Indigenous cultures and the emergence of an alternative view which actually stressed the importance of Indigenous cultures for well-being. But this all threw up something of a challenge, because if you've just dismantled 100 years of legal prohibition on Aboriginal drinking, leaving aside the question of whether it worked and how it worked, it then gives rise to a question, well, how should Aboriginal drinking be managed in the absence of this strict, very authoritarian statutory prohibition? What mix of Indigenous controls and imposed state controls were going to work best? And the most comprehensive answer to this actually emerged in the Northern Territory, which was heading into self-government at the same time. So you had a comprehensive inquiry in 1973. In 1978, following self-government in the Northern Territory, there was a new Liquor Commission established as a statutory authority with a new Liquor Act. And this new Liquor Act was, in fact, quite an innovative piece of legislation, particularly what's still called Part 8 of the Liquor Act, which actually set out a legislative framework for a high level of Indigenous community control over access to liquor. Under Part 8, communities could elect to have any system of access to alcohol ranging from total ban through to no regulation at all other than the regulation that applied across the territory, or anything in between. So they might elect to have that you could only have grog if you had an individual permit, or they might put maximum amounts that you could bring in, or they might say, well, you can bring in beer but not spirits. Anything was potentially on the table. What they did have to do was apply formally to the Liquor Commission to say, we want to have restrictions. The Liquor Commission under the Act was obliged to go to the community and try to determine what in fact was the community's wishes. And if it agreed that if the Commission felt, yeah, this is what the community wants, this would then become law. And it would become law not just as a community bylaw, but actually as territory law. So this notion, and they were called restricted areas, which is probably not the best name, because restricted areas elsewhere are actually very unilateral things imposed. But this marked a very self-conscious attempt to try to replace the paternalistic micromanagement by the state under assimilation with communities as responsible entities in keeping with current notions of self-determination. And the policies were very much picked up by communities. So within 12 months, 16 communities had become restricted areas. 10 years later, it was 66, and now there are almost all Aboriginal communities in the Northern Territory are restricted areas under the Act, more than 100. At the same time, in some ways similar moves took place elsewhere. So Western Australia introduced the Aboriginal Communities Act of 1979, which gave communities bylaw-making powers. It didn't actually, which are really inadequate, but that's another story. Queensland, you had the Community Services Aborigines Act of 1984, which actually empowered community councils to have liquor licences. And there were similar moves that I won't go into here in Canada and the US. So there was part of this broad shift as the move away from assimilation. However, another significant change, which I think has been less remarked, happened at around the same time. While these controls on Aboriginal drinking were being, or while the prohibition was being replaced by this notion of community control, you also had very important changes going on in the management of alcohol in the mainstream society. Because from the 1960s, the controls on alcohol were progressively liberalised, I see there's a misspelling in there, and deregulated. You had three main things that started to happen around that time. First of all, we had the emergence across particularly the Western world of the so-called new public health. And the key idea here is that instead of the state controlling everything you do, it's more an indirect control. We give you things like, safe drinking guidelines and so forth, and we are increasingly expected to manage our own exposure to risky practices like smoking and drinking. You also, from the 1980s, had the push from the neoliberal economists and their political allies for deregulation of the marketplace. So you had national competition policy, and so you had a fairly rapid deregulation of the sale and supply of alcohol right across Australia. And of course, the other thing you had happening at the same time is the drinks industries themselves are trying to reposition themselves in a constant search for new markets in a changing society. So the upshot of all this is that drinking today is in many ways a very different set of practices from what it was 40 years ago. We now have a much more deregulated alcohol market. We have a proliferation of different styles or cultures of consumption. I've mentioned three there, the old boozy blokes drinking culture, the getting off your face in the nightclubs, and the wine connoisseur. And you could sit down and identify. But there's been this kind of fragmentation of drinking cultures in Australia. And through all this, the notion has been very powerfully argued that the main person responsible for managing consumption is the individual drinker. And despite the fact that, you know, public health advocates like some of us are forever advocating for structural changes like taxation and controls on supply, the overwhelming discourse about alcohol problems in this country and in other countries today is about the role of the individual drinker to manage their drinking. But as we've also seen recently, the re-emergence of punitive police powers for those who don't manage their drinking in approved fashion. But what you've then got is a kind of divergence, because a lot of Aboriginal people do not have, they're marginalised by these sort of contemporary consumerist cultures. Many of them do not drink in the approved consumer styles that I talked about. And particularly in remote communities, they do not conform, and in many ways cannot conform to this model of the neoliberal, individualistic, health-conscious consumer. So again, this marginalisation in the face of this contemporary patterns of consumer culture have further marginalised, I would argue, many, not all, many Indigenous people in Australia, and have perhaps strengthened this notion that something called the community is going to be the main agent. Now, I haven't been keeping good idea on time, but okay, good. So I want to now, having given that sort of historical background, look at how this pans out in practice. And I'm going to take two examples. And I want to preface this by saying I'm certainly not criticising the idea of community control. So I hope I won't be misinterpreted to say that I am. But I am looking at some of the things that go wrong. And again, not because I think they always do go wrong, they don't. But often it's when things go wrong that you can start to see what's really going on underneath the surface. So the one I'm going to start with is a community, and I'm going back to 1979, the very beginning of all this notion of community control. To a community called Lajamanu, which might be familiar to some of you. It's located on the edge of the Tanami Desert, about 560 kilometres southwest of Katherine. At the time, it had a population of around 800, mostly Warlpiri people, and about 70 Europeans. The nearest liquor outlets, you've got there Rabbit Flat, 200 kilometres in one direction, Top Springs Hotel, 365 kilometres in another direction. I was there last week, I can tell you it's hardly a hotel. Anyway, Lajamanu applied to be a restricted area. It was one of the first in May 1979. And it was an interesting process. It begins with a letter that's sent to the Commission from the Community Council, in which stated, amongst other things, that after extensive discussion, the community wants more controls. It had a shot at the police, who it said weren't merely not supporting controls, but were actually responsible for quite a lot of the grog coming into the place. And it went on to propose 7 or 8 quite strict conditions that it wanted to bring in, including restrictions on both Rabbit Flat and Top Springs. I haven't itemised them here, but a number of conditions. That letter was dated, I think, the 21st of May. A week later, this telegram was sent to the Commission. Now, you should be, I think you probably can read it, but I will. During an Aboriginal public meeting, 9 a.m. Tuesday, 29th of May, it was decided to declare the Hooker Creek. Hooker Creek was the old term for Lajamanu. Within a radius of 5 miles around the centre of Hooker Creek, a dry area, as of tomorrow. Present at the meeting, approx 150 men and separately, approx 500 women. Also, all existing permits for Europeans and or Aboriginals to be revoked as of tomorrow. No alcohol whatsoever to be allowed within this area. Local police was present during decision taking and informed accordingly. Kindly confirm your agreement to our decisions by return telegram. We will have letter confirming above in the next mail. And it's signed by the Lajamanu Community Council. Well, a couple of days later, the chairman of the commission replied in another telegram, a fairly short one, and I've just taken one quotation here. I sympathise with your liquor problems, but must inform you that only the Liquor Commission has the power to declare a dry area. which is technically correct, but okay. The same day, we know from a file note, he phoned a couple of people from the Department of Aboriginal Affairs and had a bit of a discussion. And one of these DAA people said he was suspicious about this telegram, and he said he would go and take a look. So he went down on the 4th of June, and then 2 days later, he reported back. The DAA person reported back to the Commission, and as a result of this, the chairman of the Commission sends another telegram to Lajamanu Council. Understand you do not wish to proceed with immediate revocation of permits, but that you wish Liquor Commission to take early action under Liquor Act to declare area restricted. Well, here was the response to that. You have been misinformed by DAA Stop. The vote during meeting 29 May was unanimously for cancellation of all current liquor permits and to declare Hooker Creek a dry area as of 30th of May. At this point, the Commission decided to charter a plane and go there himself. And there was a meeting convened on the 12th of June, or the 11th of June rather, and he came back the next day and wrote a minute. And in the minute, we get some sense of the meeting, which he says most of the meeting was taken up with discussing the permits. And then I quote, "There were two schools of thought on the question of permits. One group believed that all permits, both Aboriginal and non-Aboriginal alike, should be revoked and that no new permits should be issued. A larger, more moderate group considered that all permits should be revoked, but that new permits should be issued to those people approved to have liquor by the council. After much debate, the latter proposal was adopted." So a week later, there's a letter from the council confirming that the council has no objections to the attached list of Europeans being granted permits to have and consume liquor on Hooker Creek restricted area. And there were 34 names: school teachers, nurses, storekeepers, plumber, electrician, rec officer, mechanic, and the police. There was just, ironically or interestingly, there was just one application from a non-European, and that was actually from the executive officer of the council who'd led the campaign. So whether that was, you know, if you can't beat them, join them, or a sort of final act of rebellion, I don't know. Now, I could go on with this saga, and believe me, it did go on. But I just want to, for the present purposes, just draw attention to a couple of things. First of all, we have to be very cautious here. This is very fragmentary evidence. But what I would suggest it shows is, first of all, a fairly outspoken assertion of community control over grog. It shows some of the evidence of the divisions. The fact that, for example, the separate meetings of men and women, anybody who's spent time in those communities knows how vital that can be, because often there are important differences and the women are not able to speak up publicly in front of the men, etc., etc. There's certainly an issue about whether non-Aboriginal people in that community should have the right to drink. But what we see clearly is the deployment of a kind of a soft power, that the government gets down there and basically manoeuvres through DAA basically to get the outcome it wanted. And and of course this is all done as consultation. This is an exercise. We have the meeting, we have the consultation, and lo and behold, we get the outcome we want. The second case study, fast forward to 2010. Another community, I won't name this one because these events are current. 2010, the then Department of Family, Community Services and Indigenous Affairs, FACSIA, engaged a consultant to consult with 4 communities in this region and prepare draft AMPs for each of them. The consultant did quite a conscientious job, went out to the 4 communities, had quite a lot of consultation, came up with 4 draft AMPs and submitted them to FACSIA. FACSIA then bounces it back to the Northern Territory government to make it happen, basically. So Community A, which is the only one, which is my second case study, actually endorsed the draft plan, but it added a section calling Making Our People Stronger. But the plan included one controversial element, what they call the safer drinking area. And this was in the draft plan as well as the final plan. The notion was they wanted an area 3 kilometres from the entrance to the community where people, which would be fenced and have, you know, basic facilities put there, a place that people could drink safely. And the reason they wanted this is that under the intervention, there was nowhere for people to drink that was safe. Because as you remember, drinking became forbidden on all Aboriginal land. They couldn't drink in the nearest town because of all sorts of other restrictions that the Northern Territory government had put on. The only place that people could find to drink was a strip of land on either side of a highway. It was a disastrously dangerous place to drink, and predictably, in fact, 2 young men died there. So the community desperately wanted somewhere where the drinkers could drink. The non-drinkers wanted somewhere where the drinkers could drink. Somewhere that would be safe, but not so far away that they couldn't have some control. There's a whole lot of things that they wanted to make this exercise manageable. So they said, we want a safe drinking area. But there was a lot of community involvement at this time, and it culminated in a meeting in April 2012. They obtained more than 100 signatures of adults in the community, and this is a community of a total population of 300, so the total adult population is about 150, so it's not everybody, but it's a pretty large proportion, endorsing this plan, and they sent this plan off to the minister, which might have been a tactical mistake, because there's one way to get bureaucracies offside, it's to bypass them and go to the minister. But of course they didn't realise that. I mean, they were trying to go to the highest person. So they sent this plan off to the minister and were feeling very pleased that they'd do all this community mobilisation. Silence, 3 months, no reply. They get a letter 3 months later, written on behalf of the minister, not by the minister, applauding their leadership they'd shown in developing an AMP, but saying, unfortunately, the minister cannot endorse your AMP because of the drinking area. And it goes on to say that the drinking area... Oh, I should have stressed that the drinking area was to be for a trial period of 12 months and to be independently evaluated. That was written into the proposal. The minister is quoted as saying, unfortunately, the idea of a drinking area is not supported by, quote, objective evidence-based research. She didn't think that the strict operating conditions could be enforced, and in what I think is a remarkable catch-22, goes on to say, if they were enforced, nobody drink there anyway. So, sorry. So, 2 years after this process of developing an AMP was commenced, there's no AMP. The community, not surprisingly, was quite deflated, and that deflation has remained. The drinkers, of course, mean they adapt. They're not going to stand around waiting for management plans or anything else. They've got to adapt as best they can to the laws, to the police, to everybody else. So what they're doing, they're drinking in the bushes, illegally, hastily, because it is illegal, the very kind of drinking practices that actually none of us want to endorse. Today, 2015, still no AMP. And the point I want to conclude on this is that not whether the drinking area is a good idea or not. In fact, there are good arguments for and against. The point I want to stress is that here you've had the community invited by government to enter into a partnership approach to managing alcohol, and then it gets basically trodden on in this, pretty, I think, paternalistic way, a very familiar paternalistic way. All right, so what does this all point to? What are the lessons that come out of this? Well, notions like community control and partnership communities sound appealing. They cast the relationship between government and communities in a benign light. They imply respect for the distinctive qualities of Indigenous culture and society. But I want to argue the reality is far messier than that. And this rhetoric glosses the reality. The reality is a messy social space contending and sometimes conflicting interests of power plays, coalitions, all the things that go on in any society in the world. The linkages and relationships involved cannot be confined within a community. They ramify out to suppliers and political allies and the liquor industry, etc. And I want to stress this distinction here. There's an important distinction between the community as a construct of contemporary governance and the community as the lived experience of people who live in them. And I don't have time, but I just wanted to draw attention to this. You know, one day they were settlements, the next day they were communities. Under assimilation, they're called settlements. Under self-determination, they're called communities. The communities didn't change. It was just that as objects of government, they were changed. Communities, of course, do have capacity to act collectively under certain circumstances, but they also labour under very serious constraints. For example, you can't compensate for inadequate local police protection or withstand the ploys of highly skilled vendors. And I want to conclude by saying that when we are engaging interventions, of course we need to look at the world as we would like it to be, but we must start from the world as it is and a clear understanding of the world as it is, and not be blinded by the glossy rhetoric. And if I just wind up, this understanding, I've argued, needs to encompass the multiple factors that contribute to sustaining demands of drinkers, the vested interests of suppliers in catering to those demands, and the various mechanisms, informal and formal, that are available at a local level for controlling the way drinking is done, and the various contexts within which all of these interests play out. Thank you.